Dear students, today we take up for discussion the continuation of Austin's positivism. Austin defined law as command of sovereign backed by sanction for its enforcement. Command, sovereign and sanction are the three elements of his definition of law. Austin developed a theory of sovereignty to distinguish between positive law and positive morality. Positive law is law in strict sense. Positive law is product of sovereign. This contention necessitated to identify and locate sovereign power in politically organized societies. Sovereignty is a key concept in Austin's theory. Hallmarks of Austin's sovereign. The hallmarks of Austin's sovereign are enumerated as follows. Determinate human superior, that is, an individual or a body of individuals. Externally independent, that is, free from the control of other sovereigns. Internally supreme, that is, receiving habitual obedience from the people. Absolute sovereignty, that is, sovereignty is unlimited, illimitable and indivisible. Applying these characteristics, let us make an attempt to locate sovereign in a modern state or constitutional polities. Granting without admitting that Austin's concept of sovereignty is right, can we find and locate a body of individuals in modern democratic constitutions which would stand the test of Austin's theory? United Kingdom. It is now commonplace to refer to the British Parliament as sovereign or omnipotent. It was Delome who said that the British Parliament can do everything but make a woman a man and a man a woman. Jennings thought that the Parliament could do even what Delome thought to be impossible. The Parliament can make law treating women and men alike for certain legal purposes. Bryce says the British Parliament can make and unmake any and every law, change the form of government or the succession to the crown, interfere with the course of justice, extinguish the most sacred rights of the citizen, and it is therefore within the sphere of law irresponsible and omnipotent. As Jennings observed, theoretically, it would be possible for the British Parliament to make law for the slaughter of all blue-eyed babies in England, or repeal, for instance, the Indian Independence Act and convert India into a colony again. But practically, the sovereignty of Parliament could not reach those impossible limits. The question of sovereignty of British Parliament would become problematical when we consider the possibility of a particular Parliament making a law which is to remain unchanged by future Parliament or not. If it cannot, it necessarily follows that the present Parliament is sovereign and omnipotent. For instance, the Union of Scotland Act of 1706 contained some provisions which were to remain unchanged forever. Nevertheless, some of these provisions were later repealed. Here, it must bear in mind that it would be wrong to assess the sovereignty of Parliament with reference to a particular Parliament as against future Parliaments. The Scotland Act example would show that Parliament as an institution is sovereign, but Austin himself was faced with a problem in locating the sovereign in the United Kingdom. He first thought that the Crown, House of Lords and the House of Commons were together the sovereign. But the House of Commons is an elected body, and hence it is the people who elect the House that have the last word. Hence, Austin corrected himself and said that it is the Crown, the House of Lords and the electorate that are sovereign. As Dias pointed out, treating the electorate as a part of sovereign authority would render Austin's theory meaningless, as the subjects themselves would be transformed into a sovereign. USA and India. The problem of locating the Austinian sovereign is more acute in the case of federal constitutions like those of the United States of America and India. Under both the constitutions, powers are divided between the federal and state governments. Austin would not countenance the division of sovereign power and would held that neither the federal nor the state governments are sovereign. Within the federal as well as the state spheres, powers are again assigned separately to legislature, executive and judiciary. Hence, Austin thought that in a federal constitution, sovereignty could be located only in the constitution amending body. This view is, however, open to criticism. Under the United States Constitution, for instance, an amendment to the Constitution can be made only by following procedure laid down in the Constitution itself. Thus, the amending body itself is subject to the Constitution and cannot do as it pleases. The same is true under the Indian Constitution also. Even if the above criticism is to be ignored as merely relating to procedure, it may be pointed out that the US Constitution amending body is subject to substantive limitations. It cannot, for instance, deprive a state of its voting rights in the Senate without that state's consent. In India, the Constitution can be amended by 2/3 majority present and voting in both the houses of Parliament. However, to amend certain provisions of the Constitution, ratification from half of the states is required. Parliament is not the sole authority to amend any provision of the Constitution. Further, in the case of Kesavananda Bharati versus State of Kerala, the Supreme Court of India has held that the basic features of the Indian Constitution are beyond the reach of Constitution amending power. Thus, the amending bodies are subject to many limitations. Therefore, designating such a body as a repository of sovereign power is untenable. By locating sovereign power in legislative bodies, Austin's theory led to a conclusion that if a rule emanates from legislature, it is law, otherwise it is not. In a unitary state, there is one legislative organ like British Parliament. If it is a federal state, there are two legislative bodies like Parliament and state legislatures in India. In unitary state, it is indivisible sovereign, whereas in the federal state, it is divided sovereign. Sanction. Austin regards sanction as an essential element in the definition of law. Every command is also expression of a wish or desire, but every expression of a wish or desire is not a command. The essential element of command, according to Austin, is the threat to inflict an evil or pain in the case the command be disregarded. So, sanction means, to borrow the words of Jerome Hall, the threat to inflict an injury, harm, loss or deprivation of life on the person who violates the command. So, what assumes the observance of law strictly so called is its enforcement by a sanction, and this is the acid test to distinguish it from rules which are laws improperly so called. But the compliance or observance of law strictly so called can be achieved not only by threat of evil consequences, but also by promise or inducement of a reward. In fact, some jurists have defined sanction to mean not only a threat of punishment but also a promise of reward. Austin rejects that connotation of sanction on the ground that it derogates from the conception of law as a command. As far as Austin's theory is concerned, the relationship between commands and sanctions is important. A sanction will follow if failure to obey the command. Obligations are defined in terms of sanctions. This is a central tenet of Austin's imperative theory of law. Exceptions to Austin's definition. Austin defined law as a general command of the sovereign attended by a sanction for its enforcement, but he was aware that all laws cannot be so characterized and that there are laws which are not enforced by sanctions. The exceptions he noted are declaratory laws, repealing laws, imperfect laws, and laws of procedure. Declaratory laws, which merely explain or interpret the provisions of other laws. For example, the General Clauses Act, which defines certain terms of common use in statutes, interpretation clause in various statutes, and definitions in modern enactments. Repealing laws, which do not contain any command to the subjects, but only free them from the obligations of earlier commands. For example, the Excess Profits Tax Repealing Act, which relieved the people from the obligation to pay a particular tax which was in force previously. Imperfect laws are those whose obligations are imperfect. They are not imperative. No sanction is attached to them. It is left to the discretion of the individual concerned to adopt the law or reject the same. For example, the Debt Relief Act, which merely provided that if a debtor chooses to pay a prescribed percentage of his debt within a prescribed period to his creditor, the entire debt will stand discharged. The obligation to follow this beneficial provision is not imperative on any debtor. He may adopt it or may not adopt it. Laws of procedure are not directives to the individuals. It prescribes a procedure to be followed by judicial bodies. For example, the law of evidence prescribes that communication of a spouse to another spouse should not be disclosed in courts as evidence. Austin points out that case law, that is, law made by judges in decisions of cases, does not present an exception to his statement that laws are general commands of the sovereign. A judge is merely minister of the sovereign, and in deciding a case, he is only exercising the will of the sovereign by delegation. The force and authority of a judge's decision are really the force and authority of the sovereign. The decision of a judge is therefore a virtual or tacit command of the sovereign through his deputy. Criticism of Austin's theory of law. Criticism of Austin mounted steadily during his lifetime. Specifically, the following criticisms were leveled against his work. Linguistic looseness. Linguistic looseness was said to have produced ambiguities in the formulation and expression of Austin's theory. Thus, the term command has precise connotations, suggesting an individual who issues orders in peremptory fashion. It was difficult to employ with precision a term of this nature in referring to the content of some legislation. The absolute sovereign is rare. The untrammeled absolute authority of the sovereign, which Austin postulates, is rarely found in practice. Confusion of sovereignty de facto and de jure. In England, the crown is the de facto sovereign to whom subjects owe allegiance, but Parliament is the de jure sovereign invested with a monopoly of legislative powers. Narrowness of the theory. The maxims no law, no sovereign and no sovereign, no law are not correct and have no application to early regimes. Much of early law results from religion and custom, not from political sovereign. The theory ignores the essence of common law. English common law, which is fundamental to the legal system, is predominantly a judge-made law which does not emanate from the command of sovereign. Historically unsound. Henry Maine argues that Austin's theory is historically unsound and untrue. The theory postulates that law is a product of state or political organization. Without the state, there is no law. But it is not true. Law is older than state, and customs are laws apart from the state recognition. In primitive societies, where there was no political organization, law did exist, though of course in a primitive form. Those primitive rules of law were also observed by those for whom they were intended. The observance of those primitive rules was secured by an enforcement machinery which was also equally primitive, that is, public opinion manifested through excommunication, etc. All the same, those primitive rules were also laws. To the above criticism, Salmond has given a reply by way of defense of the Austinian theory. Salmond observes that the man in the modern sense might have evolved from the anthropoid ape, but we do not define a man so as to include an ape, and likewise we need not define law in the modern sense so as to include the primitive rules. Salmond observes, if there are any rules prior to and independent of the state, they may greatly resemble law. They may be the primeval substitutes for law. They may be the historical source from which law is developed and proceeds, but they are not themselves law. So, Salmond points out that Austin defined law in the modern sense, and his definition was not intended to include primitive rules. Salmond's analogy of ape and man is misleading and false. If one has to compare the development of law with the evolution of man, the analogy that has to be taken is that of primitive man and modern man, and not of ape and man. So, it is submitted that just as a definition of man should include the primitive human being, a definition of law should also be wide enough to include the primitive rules of conduct. Not comprehensive. The criticism that is leveled against Austin's theory is that even assuming that it is a definition of law in the modern sense, it is not comprehensive enough to include all modern kinds of law. International law, not being a command of the sovereign, does not fit into the definition of law given by Austin. In fact, Austin refused to recognize international law as law strictly so called and dubbed it as positive morality. The same is the case with customary law, common law, constitutional law, and canon law. Uncodified Hindu and Mohammedan laws are outside the scope of Austin's definition. Case law is missing from it. The fact is that so many branches of law do not fall within the scope of Austin's definition. His definition is too narrow and is applicable only to a statute passed by the omnipotent British Parliament with which he was so very familiar. Austin disregarded ethical element. Salmond observed that Austin's theory of law is one-sided and inadequate, the product of incomplete analysis of juridical conceptions. By defining law as a command of the sovereign, Austin has ignored ethical purpose of law, namely justice. Law is not just an arbitrary command. Law is also an instrument of justice. No doubt, an element of force is there, but equally also an element of justice. Force and justice are the two horses that draw the great chariot of law. Law loses its real significance if either of the two elements is found lacking. As Blaise Pascal once observed, Force without justice is tyrannical, and justice without force is powerless. Emphasizing the point that law has two aspects, the aspect of force and the aspect of justice, Salmond observes, law is not right alone or might alone, but the perfect union of the two. Salmond further observes that it is not by a mere accident or coincidence that in popular speech law is associated with justice. Courts of law are also courts of justice, and the administration of justice is also the enforcement of law. All laws cannot be characterized as commands. There are laws which are not commands, but simply power conferring rules. For example, election statutes, rent acts, etc. They confer right on citizens to vote, to pay certain amount of rent and no more. In every state, there exist some basic rules that define sovereignty, but these rules are not themselves the creation of the sovereign. Rules of succession in England prescribe who shall inherit the throne before he issues any command. Austin defined a law, not the law. Salmond makes a distinction between law in the concrete sense or a law and law in the abstract sense or the law. A law means an act of legislature, statute, an enactment, a rule or ordinance. Thus, Indian Penal Code is a law, but Indian law is the law, and so also the law of crimes is the law. The law or law in the abstract sense has three sources, namely legislation, custom and precedent. Thus, the law is not made up of legislation or a law alone. Salmond points out that all laws do not produce law and all law is not produced by laws. In England, the system of obtaining divorce through a judgment of a court of law was introduced in 1857 by the Matrimonial Causes Act. Prior to that, a couple could get divorce only by an act of parliament called private acts. The purpose of a private act was only to declare that Mr. and Mrs. X are divorced and are no more husband and wife. But this private act, though a law or statute, was applicable only to the parties concerned and not generally to all. Thus, all laws do not produce the law or law in general. Salmond points out that Austin, while defining law, did not keep in mind the vital distinction between a law or law in concrete sense and the law or law in the abstract sense. Consequently, Austin defined law in the concrete sense, whereas he ought to have defined law in the abstract sense. Statutes are only one of the sources of law. Legal principles are gatherable from other sources as well, such as precedents and customs. Hence, the entire body of legal principles is not produced by statutes. Law, not the state, is supreme. If law is defined as the command of a sovereign to his subjects, constitutional law, which purports to lay down stringent restrictions on the powers and the activities of the ruler himself, cannot come within the definition. Austin's definition confronted with a problem, that is, whether state is bound by its own law. In fact, the position at present is state is bound by its own law unless exempted from the application of law either expressly or by necessary implication. Austin held the view that even constitutional law is positive morality, but in modern states, constitutional law is regarded as a law governing the governments. Government is under the law, not above the law. The lawmaker is not above the law. Austin had in mind a sovereign lawmaker who himself is not bound by the rules he promulgates and is therefore above the law. But this does not reflect the reality of the legal system as we know it. Thus, The House of Lords is bound by the provisions of the Parliament Acts. The Queen is bound to summon Parliament to meet every year, and the House of Commons is bound by its own strict rules of procedure. Austin's view of the legislature as being subject to no rules is not correct. Radbruch's criticism. Gustav Radbruch's main criticism against Austinianism is that it leads to dictatorship, as happened in Germany during the Nazi rule. During the Nazi regime, Hitler's word became law unto himself, and he constituted himself the supreme commander, the supreme legislature, and the highest German court. The Germans had no rights, liberties, freedoms, and were subjected to monstrosity of secret statutes, secret regulations, and secret police in complete defiance of morality and justice. Radbruch says laws can never be separated from morality, justice, and democracy, which he describes a higher law. The influence of Austin. The vitality of Austin's theory, which is known for its simplicity and consistency, is still far from exhausted. For a systematic exposition of the methods of English jurisprudence, we still have to turn to Austin. Many jurists, however, see the command theory as devoid of any relevance for our day. Austin's successors in the positivist tradition have abandoned his concept in favor of other formulations. Holland concentrated not on command, but on enforcement by sovereign political authority. Salmon spoke of law as consisting of the rules recognized and acted on by the courts of justice. Kelsen developed grand norm theory. Hart viewed law as a system of rules. Impact of imperative theory on the Indian legal system. In A.K. Gopalan versus State of Madras, where petitioner had been detained under the Preventive Detention Act 1950, the Supreme Court was approached to pronounce upon the true meaning of Article 21 of the Indian Constitution concerning personal liberty. As to Article 21, the court held that the words according to procedure established by law in the article meant according to substantive and procedural provisions of any enacted law. The court interpreted the term law in the positivist sense of state-made law. The approach of the court was dominated by the imperative theory of law. This lesson, including the preceding one, is a critical analysis of Austin's contribution to analytical positivism. Thank you.